This now is retired Judge Jim Barretto. He's following this trial closely. Judge, thanks for your time. We always appreciate it.
Good afternoon, Ben and Erica.
All right, so let's talk about the instructions. They're going to get a number of options. If you will here, maybe compare that to the Karen Reed case, because that jury did not have a number of options necessarily that they felt like they could turn to. Does that make it harder for a jury, do you think?
I think it does make it harder for a jury not to have options. Jurors, frankly, compromise. And when there's off-ramps from something they don't want to do, it can help them reach a verdict rather than produce a mistrial, a hung verdict, if you will. In this case, they were going to get first-degree murder. That's what Lindsay Clancy is charged with, so we knew that, of course. And then they were also going to get second-degree murder because the model jury instructions require that. The only surprise was that the judge said he was going to charge on manslaughter, but not differentiate between involuntary and voluntary manslaughter. And that I got to hit the books tonight because, frankly, I didn't understand that.
Okay, it's been a long 5 weeks of this case, which attorneys will recap in their closing arguments tomorrow. They each have an hour. What do you think each side needs to do tomorrow?
Well, can you imagine closing where you have to summarize over 300 exhibits, 70 plus witnesses, and come up with a coherent narrative that makes something understood that frankly defies explanation? That's what each of these attorneys will have to do tomorrow. Of course, the prosecution will focus on purposeful conduct, on the range of decision makings that Lindsay Clancy had to have navigated in order to get to kill those three young kids. And the defense, of course, will again emphasize that she was in the middle of a serious psychiatric postpartum illness. They'll call it psychosis. We've heard from experts as to all kinds of things it could have been. But the point is, they will hammer away that she had no capacity to understand the wrongfulness of her conduct, nor could she conform the conduct to the requirements of the law. So these attorneys have quite a formidable task in front of them in preparing their closings, and I can assure you they'll be up late tonight doing that.
So, Judge, quickly, in your experience, do you think generally jurors at this point in the trial have their minds made up, or do they wait to go into that jury room to make up their minds?
I very much do not think they've made up their minds. I think they'll follow the instructions. That's my experience, almost 16 years on the bench. They follow the instructions, and they haven't even been instructed on the law, and they haven't heard closing arguments. Now, closings are not evidence, but they're an opportunity to give them some guidance as to how to receive and analyze this evidence.
Okay, Judge Barretto, thank you as always for joining us.
Thank you.